Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II.
Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II, principal at Carter Arnett in Dallas. Bob has more than 35 years of experience handling complex business, intellectual property, and real estate disputes in Texas and federal courts nationwide. I'm Lisa Mosby, your host, and today we're discussing early case strategy in commercial litigation and what takes shape in the first 90 days after a lawsuit is filed. Bob, thank you so much for joining me for this conversation today.
Yeah, good to be here.
You know, Bob, at the onset of a commercial dispute, what tends to define the direction a case will ultimately take?
Well, there's a number of factors. One is, is there injunctive relief in play? If the plaintiff has filed a lawsuit and sought a temporary restraining order and perhaps obtained one, then there's going to be a lot of activity pretty early on in the case to get ready for and have a hearing on a temporary injunction in state court or a preliminary injunction in federal court. So that's one factor. From the defense perspective, there's also, considerations about whether there's a challenge to personal jurisdiction that's available, whether the case is removable either to federal court or the Texas business courts, which are a fairly new branch of the courts system in Texas, and potentially whether there's bankruptcy, a potential bankruptcy filing that may affect the proceedings, and then whether there are early motions to dismiss. Texas now does have a motion to dismiss rule that allows you to file, and it has to be filed within 60 days to dismiss causes of action that have no basis in law and no basis in fact. Federal court, of course, Rule 12b has a variety of different kinds of motions to dismiss that can be filed early on, which tends to create greater litigation activity at the front of the case than if you just simply answer the case. So, a number of factors. I guess one other one that I would mention would be, is there a possibility of a mandatory arbitration provision in play? Those can be enforced in some circumstances, even against people who are not parties to the arbitration agreement. So, that would be another factor to take into consideration.
Bob, once a lawsuit is filed, how does initial case assessment unfold from a strategic standpoint?
Well, I think, it depends in part on some of the factors I've just identified. What procedural situation do you find yourself in? If you're, attempting to get ready for injunction hearings, there's going to be a lot of activity on the defense side trying to get up to speed on the facts and what the actual situation is. As well. I mean, that's also affects the plaintiff as well. They've got a lot of work to do to get ready for an injunction hearing. The other issues are, less so in federal court, because most motions to dismiss, whether it be for failure to state a cause of action or personal jurisdiction or subject matter jurisdiction, there's the federal courts generally decide those without a hearing, but it can take 2, 3, 4, maybe as long as 6 months for those motions to be decided in federal court. In state court, motion to dismiss has to be decided fairly quickly, otherwise it's deemed overruled by operational law. So that moves things along pretty quickly. So I think those are the factors that you would guide or impact how the case is going to unfold.
And then how do the early pleadings and responses influence leverage between the parties in those first stages?
I mean, in terms of leverage, I guess, when I think of leverage, I'm thinking of settlement, pushing a case towards settlement. So if there's an injunction that's granted that, really is a problem for the defendant, that can create a great deal of leverage to try and get the case resolved pretty quickly. Or if, there is a motions to dismiss that are filed that seem to have a lot of weight and substance to them, that can influence or create leverage to try and get a case resolved. And on the defense side, it's you can file a counterclaim and seek injunctive relief. I've seen defendants do that in some circumstances, and if injunctive relief is granted, or if there's a prospect that it's going to be granted, then that can create a lot of leverage.
What factors typically drive decisions around whether to pursue an aggressively early posture versus maybe a more measured approach?
Well, that would depend on the nature of the case. In some circumstances, you've got a fairly common type of case is former employee of one company leaves, joins a competitive company, and there's concern that they've stolen trade secrets, or they're taking trade secrets and are now using them to compete. That would argue for a very aggressive early approach by the plaintiff to try and get that situation under control and minimize the damage. So, that would be one circumstance where a plaintiff would want to be extremely aggressive. From the defense side, if you've got a good motion to dismiss, that can be something that you want to pursue pretty aggressively. Or if the case has started out in state court and the defendant wants a more favorable forum and they can remove it to business court or to the federal courts, that's something that has to happen very early on in the case.
Let's talk about some definitions. We hear preservation of evidence and internal information gatherings. What are they, and how do they shape the trajectory of a case early on?
Well, so preservation of evidence, once a party is aware that litigation is likely, they are under an obligation to preserve evidence that might be relevant to the case. Generally speaking, if there's a demand letter that's sent pre-litigation, it will oftentimes include a demand for preservation of evidence, and that should trigger on the defense side, an internal communication to potential custodians of relevant information to preserve those bits of information. If there are, a situation where you've got surveillance video that may be relevant, a lot of times surveillance cameras, the video footage is maintained for a certain period of time until it's overwritten, which can be, as short as a couple of weeks or perhaps 30 days. In that circumstance, you need to get communication to your vendor, or if it's internal, an internal group that does that sort of IT work, is to say, preserve this footage. Don't let it be overridden. Copy it, set it aside, so that when somebody wants to look at it later on, it'll be there. All of that is to prevent a spoliation of evidence argument, which basically is usually brought by plaintiffs against defendants, saying, you had this evidence, you allowed it to be deleted or destroyed, or you deliberately did that. And in that circumstance, I'm entitled to some sort of relief from the court, perhaps an instruction to the jury that they can presume that the deleted evidence would have been unfavorable to the party that deleted it, as well as, potentially, if it's egregious, having issues determined against you by the court. So, it takes things off the jury's plate in terms of what they're deciding. And, you as the party that's being punished, kind of wind up behind the eight ball.
Don't do it. Don't do it. Bob, in cases involving multiple parties or maybe complex business relationships, how is responsibility evaluated before formal discovery is fully underway?
Well, I think that has to be evaluated as part of formulating your discovery plan. You need to figure out, are there other parties that need to be brought into the case? Are there parties that maybe you don't want to bring into the case, but you want to identify in Texas state court as responsible third parties? as you get into the case, it's also going to be something of an evolving situation because, there may be parties who were involved that you as the plaintiff were not aware of, or you were aware that they were involved, but you weren't entirely sure what their role was. And as that becomes clear, you need to get discovery perhaps directly from them, which you can do by way of subpoenas or depositions. It's something that from the plaintiff's side, you ought to have an idea of what discovery you need before you even file the lawsuit. From the defense side, if it's been an ongoing dispute, and there's been, some back and forth, there have been demand letters or responses to demand letters, the defendant should have some idea what the scope of the dispute is and what sort of discovery they're going to need. But sometimes defendants get sued out of the blue, and you're, needing to try and get your arms around what discovery you need fairly early on in the case. Now, in both Texas state court and federal court, there is in most cases, unless there's some sort of expedited process going on, like injunctions, in federal court, you've got to have what's called a Rule 26F conference, and then, you generally file with the court a discovery plan before you can launch into formal discovery. On the state side, it's you can't serve written discovery other than serving initial disclosures within like the first 30 days or so of when the lawsuit starts. Really, it's tied to when the answer is due. So it's 30 days after the answer is due.
I'm really trying to get my head around strategy using all of these different positions, early motions, including judicial challenges or motions to dismiss. How do they fit into the case strategy? Are they things that you plan for? Are those strategized on before the rest of the case develops? Can you kind of explain that process just a little bit to me?
Well, sure. So there's different types of early motion practice.
Mm-hmm.
There is challenging the court's personal jurisdiction over a particular defendant. Under the United States Constitution, the defendant has to have certain minimum contacts with the jurisdiction in order to be brought into court in Texas, for example. Now, those are somewhat different as to how that's approached in federal court versus state court. In state court, that's done by way of what's called a special appearance, which has to be the first thing that you file. So you can't answer a lawsuit in Texas state court and preserve a challenge to personal jurisdiction. If you answer and before you file your 120A, your Rule 120A motion, that you've waived it. You've made a general appearance and you're there. So that's something that you need to be aware of. In federal court, you can answer, but also raise lack of personal jurisdiction as an affirmative defense, and then move on it. In federal court, in state court, you're going to have a hearing fairly quickly, or in most cases. Sometimes it's a fairly complicated case, and you need to have jurisdictional discovery. So the court will allow the parties to conduct depositions, exchange exhibits, send written questions called interrogatories to get to the question of the defendant's contacts with the jurisdiction, and is that sufficient to hold them in Texas? So that can take some period of time to get through. And then, typically in state court, you will have a hearing, and the judge will decide the motion, hopefully fairly soon after the hearing. In federal court, you generally don't have a hearing. You just, file the papers, and, the judge decides it within, the time that the judge has to decide it. So, that's some of the differences there. Subject matter jurisdiction is more of an issue in federal court, because the federal courts are courts of limited jurisdiction. Their jurisdiction is generally limited to issues of diversity of citizenship jurisdiction, which is a lawsuit between citizens of different states with at least $75,000 in controversy. And, that inquiry can become fairly complex because, if you have multiple parties, multiple defendants, multiple plaintiffs, there has to be complete diversity. You can't have anybody with the same citizenship on either side they call it either side of the V. So plaintiffs on this side, plaintiffs versus defendants. So there has to be complete diversity, which can also become a complex inquiry because certain types of business entities, particularly limited liability companies and limited partnerships, have the citizenship of each one of their constituent members. So, that can be, and that's daunting for a plaintiff because, you got an LLC on the other side. Who the members are generally is not public information. So, you may, find yourself getting thrown out of court if you haven't done your homework or it turns out that you've got people in Texas who are part of that LLC, and your client is a Texas citizen. So, that can happen. I've seen that happen.
Bob, what is the role of early settlement discussions play in the first phase of litigation, particularly before the full factual record has been developed?
Well, early settlement negotiations are rare.
Okay.
It's typically the case is going to go on for a while before there's really any serious effort to try and get a case settled. In most cases, in some cases, as I said, if there's an injunction that's entered against one side or the other, that's really problematic. Now, there is a right to an immediate appeal from an order that either grants or denies an injunction. So, that process can be going on. But at the same time, if there's, if you've been stopped from doing something that's important, you may really be incentivized to reach a settlement as quickly as possible. So, that's certainly one circumstance where there can be early settlement negotiations.
Perfect. For corporate counsel managing a new lawsuit, what strategic considerations tend to matter most during those first 90 days? And that's where we'll wrap it up for today.
Well, assuming we're talking from the defense perspective, it's, what impact is this lawsuit going to have on the business going forward? Or what are the threats to the business going forward? What potential impacts is this going to have on, other parties who are similarly situated? And here I'm thinking of, a company that has, just hired some people from a competitor, and now they're getting sued for tortious interference and misappropriation of trade secrets. Do we have exposure? And if we do, what can we do to minimize that and try and get rid of this? And what can we do to try and prevent this from happening in the future?
Well said. Thank you so much for your insights today, sir.
All right. Good talking with you.
Yeah, folks, that's it for today's episode of the Texas Commercial Litigation Podcast with J. Robert Arnett II of Carter Arnett. To learn more about Bob and his firm's work in business and in intellectual property litigation, visit carterarnett.com. Thank you so much for listening. And remember to like, subscribe, share this episode with anyone interested in how commercial cases are handled in Texas courts. And we'll see you next time.
All right. Thanks very much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.